Reeves Immigration Law Group now brings you immigration law on your side.
Alright, magandang gabi po mga kababayan. It's Kuya Yo coming from Las Vegas. Ito pong Immigration Law on your side. Today, the 6th of December 2023. At marami sa inyo ang nakapanood na at nalaman na kung anong nangyari dito sa Las Vegas ngayong araw na ito. At nagkaroon ng active shooting situation dito po sa UNLV. So tumutok lamang, we'll give you updates on that one here at the PHLV radio platform. In the meantime, maganda pag-uusapan natin ngayon sa immigration law on your side. Denial. Nako, mainit na pag-uusapan talaga yan kasi ang denial masakit pakinggan. Ano po ba ang mga common reasons for denial? Ano? Kasi mga kababayan, getting an application denied by the USCIS can really be heartbreaking. It can be particularly tough with the extensive process associated with your petition, and you probably spent a lot of money and time, alam mo, getting all your documents ready to file and para mag-prepare pa sa mga interview, only to find out that your case is denied. Naku, masaklap ito. Fortunately, mga kababayan, denial does not mean that all hope is lost. So kasama natin yun, napapanood nyo sa screen, si Attorney Diza, Flomy Javier Diza, partner at Reeves Immigration Law Group, to discuss the common reasons for denial of your application. And ano po ba ang mga possible solutions nito or options ng mga nabigyan ng denial? So magandang gabi po sa iyo, Attorney Diza.
Magandang gabi, Kuya Johan, and of course, babatiin na rin natin yung mga taga Las Vegas, lalo lang dyan sa area ninyo. Sabi mo nga, may active shooting at tinignan natin sa internet kanina and hopefully na-contain naman na, no? But this has always been a common problem dito sa US, yung shooting na yan. But banggit mo nga kanina, pag-usapan natin is denial ng inyong visa application. Magpapasko pa naman at this is our first episode ngayong December, at pag-usapan natin denial, pero para bigyan po namin kayo ng magandang pamasko ay pag-usapan natin kung paano po natin re-remedyohan ang inyong na-deny na petition or application. So tumutok po kayo, makinig, manood, at siyempre pakishare na rin po ang ating programa at lahat ng programa ng PHLV Radio.
Maraming salamat, Attorney. Para bang yung wish list mo kay Santa Claus ay hindi ibinigay, na-deny. So paano ngayon? Yung regalo ngayon, mukhang masaklap ang Pasko. Pero I'm sure, Attorney, merong pwedeng gawin ng ating mga kababayan. So what can our kababayans do if they get a denial? If they get a denial by mail, nalaman nila na, yung pinaghirapan natin, na-deny. Paano po, Attorney, ang gagawin nila?
Yes, very common sa ating mga kababayan na syempre kinakabahan na yan, di ba? Because there are consequences of when your application is being denied, right? There's a probability that, number one, you fell out of status, right? Or number two, you will be issued a notice to appear, right? Because you violated your immigration status. So, most of our kababayan ay syempre ninenervyos or kinakabahan na. So, the very first thing that you should do, of course, is aside from evaluating the reason for the denial, is of course to consult an immigration attorney, right? Very important yun kung ano po ang, dahilan but na-deny. And even if the denial is self-explanatory, right, it's also important, to know the consequence. Attorney, na-deny ako, alam ko I can refile, right, or probably file a reconsideration. Magko-comply lang ako, di ba, kung ano yung hinihingi nila, but that's not enough because there's an adverse consequence of, the denial. So number one, of course, is, evaluate, understand, and see the reason, for the denial. Yun ang unang gagawin natin. Siyempre, and through the help of an immigration lawyer, and the best way to go moving forward to either, number one, to either refile your application or file a reconsideration or appeal.
Attorney, normally ba ang denial, well, obviously you'll probably get it by bail, but how else are you going to find out na na-deny yan? Is it online as well? I'm sure pwede nilang makita sa online or pinapadalan ba ng sulat ang ating mga applicants?
Yeah, marami ng mga applications ngayon sa USCIS that can be done online. So if you subscribe dun sa online or nag-register po kayo ng online account with USCIS, usually yan, mayroon parang ano yan, Kuya Johan, parang email yan, di ba? Or parang text message yan na may notification sa'yo. Or halimbawa, nagamit yung credit card nyo, minsan may mga alerts, di ba? So, yan, pwede kayo mag-subscribe ng alerts sa inyong account, sa USCIS account, right? Or through your lawyer, or through your cell phone, by online. So, usually yan, kung may alert sa inyo, right, you still have to go to your account, to either see the actual decision, right? Or you can also wait dun sa mail po ninyo or sa inyong representative. So, ang denial or letter of denial, either denial yan or approval yan, would also be sent through mail, Kuya Johan. So, very traditional pa rin ang law firm namin. So, we do both, right? You do both para to make sure that, hindi natin mamimiss kung ano man ang mga notices ng USCIS.
That's right. Attorney, one time pinag-usapan natin yung request for evidence, yung RFE. When you file something, sometimes you will get a request for evidence, mga additional documentations na kailangan mong ibigay. Probably, hindi mo na ibigay, you were not able to respond properly and at the proper time. Would that be a reason for a denial?
Yes, very important to look at the request for evidence because they will give you a time frame to respond, right? Usually it ranges from 30 days, may 60 days, may 90 days. So some people, think that, dati nakakuha ako parang 90 days ang binibigay sa akin. But usually yung mga notice of intent to deny, right? Binibigyan ka lang ng 30 days. So make sure that you look at the, yung notice kung kailangan mo dapat mag-respond, diba? So that's number one, right? So failure to respond to the request for evidence will definitely cause a denial of your case. So not only that, Kuya Johan, even if you responded, but it's incomplete, right? So it's important again to look at the request kasi ang pagkakaalam mo is ito lang nire-request, kulang lang ako ng medical, yun lang sinubmit mo. And then yung pala may mga additional requests pa kagaya halimbawa na in a marriage-based context, right? Now usually USCIS, in order for them to waive the interview, so instead of you calling for an interview, nag-request na rin sila ng joint documents. So just make sure that you have the checklist and complete it. Kung ma-checkan po ninyo that you have complied, di ba? Minsan in a request for evidence hindi lang isang bagay ang hinihingi, di ba? May mga pagkakataon na lahat hinihingi niya, which is a good thing kasi lalong-lalo yung may mga nagpa-file ng application by themselves, syempre, di ba, minsan, na-overlook. So, ngayon, tulad ng minsan yung medical, joint documentation, or yung affidavit support. Minsan, kulang yung evidence with regard to the sponsor. So, in essence, Kuya Johan, if you don't respond or fail to respond or you responded but incomplete, that could be a cause for denial. Now, ano ngayon ang paraan para, hindi ma-deny? Of course, you have to comply and read very carefully and comply with the request. But once the case is denied, right, you have to refile. Ang problema dito, Kuya Johan, yung mga non-immigrant visa, halimbawa, nagre-request ka ng extension ng H-1B, di ba? Or yung mga L-1s or student visa, right? Kapag kasi na-deny ng application mo, right, nawawala na overstay ka. So, it's really scary pag nag-overstay ka, lalo kung naghihintay ka ng employment-based na petition. So, again, you have to consult an attorney to make sure that you're doing the right path. But in a family case, for example, like a marriage-based cases or your petition by your son or daughter, right, at nagkulang kayo, you fail to respond or na-deny because of failure to respond to the request for evidence, right, you can always refile. But of course, number one, that's going to be additional, another fee rather, right? Kasi mawawala na yung fee mo. But if you think, mga kababayan, that you responded well and you think that your response is complete and USCIS is saying that, look, we did not respond. I mean, it happened to me like few months ago, Kuya Johan, where we filed our response, right? And the immigration was saying they never received the response. But what we have proof that, we FedEx it and we trace it and we inform them that, look, it was received by, this person in your office. So we filed a motion to reopen and reconsider And of course, aside from saying that it was received, we also provided them the missing or the requested documents just to make sure. And fortunately, Kuya Johan, that case was ultimately approved.
Nako, oo, kaya maganda talaga na nasa pangangalaga tayo ng mga capable and very, very qualified attorneys. Attorney, ilan din sa mga episodes natin in the past, we talked about, for example, itong marriage-based petition, and where you have to prove to immigration na totoo yung marriage na yan. What if na-find out nila na itong marriage pa lang ito was out of convenience, it was fixed? Would that be a denial, a reason for denial?
Yes, ang marriage fraud, mga kababayan, is one of the toughest, immigration consequence. Now, if immigration finds you that you committed marriage fraud, then there are adverse consequences. Yung tinatawag natin provision ng Immigration and Nationality Act under Section 204C, meaning that even if you marry someone else in the future, for example, the immigration found you to have committed marriage fraud, right? The petitioner admitted that, there was no relationship, right? Or admitted that he was being paid, right? And you did not cohabit, or live together as a couple, and there was a written admission. Well, it's going to be very, very difficult for you to get your visa or your green card, moving forward. So, for example, you found someone else to marry, right? Or yung anak mo, 21 years old na, from prior relationship, for example. Akala mo it's going to be easy to get your green card already, and the answer is no, because of this marriage fraud. It will go with you till forever. Baka nandyan yan, unless you overcome. So, what the remedy would be if you believe that your marriage is legitimate, right? You have to fight for it, right? You have to fight that it's legitimate. You have to see a reason why the petitioner might have said something different. Lalong-lalo sa mga stocks interview or yung mga enhanced interview, Kuya Johan, where people or the applicants and the beneficiary are called for an interview tapos pinaghihiwalay, di ba? During the interview, and they are asked the same questions, although separately, and they have to match your answers. So there are situations that in this case, sasabihin ng immigration, you failed to establish your relationship, right? So anong remedy natin kung magkaiba ang mga sagot ninyo, right? Then of course, probably there's a language barrier. Right, you have to, ask, and you have to tell your lawyer the reasons why this person is saying different, facts than what actually transpired. So yung ganun, Kuya Johan, pwedeng i-refile, right? But make sure that when you go to the next interview, you have to understand the questions, right? Don't just answer the questions na ito ang gustong marinig ng officer, di ba? Na sabi mo anong kinain nyo kahapon, and sasabihin mo, we went to a fancy restaurant and we dined together, pero the reality is nag-take-home lang kayo ng halimbawa, right, ng Burger King or, McDonald's, and that's okay to say na, okay, we just got some burger and we eat dun sa bahay. So, as long as you tell the truth, wala namang problema di ba? So, you have to really tell the truth. Kung hindi ka rin pwede mag-guess. So with the representation of a lawyer, Kuya Johan, and preparation, right, and understanding the case, we might also request an interpreter para lang maintindihan yung gusto. Kahit sabihin natin, I can speak, English, I understand fully well, but there are situations na yung the way you say, the way you respond, minsan ibang interpretasyon ng officer because of cultural differences. Yung officer mo is Caucasian or yung officer mo halimbawa from Southern America, iba ang interpretasyon nila sa sinasabi mo, right? And again, I mean, you have to really explain those things. So either you refile to overcome the marriage fraud finding. That's the option for people who have failed to establish their relationship. So hindi lang sa mag-asawa po yan, pwede rin sa anak na nagpe-petition sa magulang or magulang pe-petition sa anak, at kung nakita nila na may late registration ng inyong birth certificate, they will question, it raises a red flag. Anak mo ba talaga to, di ba? So, they might require you for a DNA test, right? So, if the DNA test yield na, anak mo naman 99.9%, and then you'll be approved. So, yun yung mga sitwasyon for failure to, establish a relationship, either by marriage or either by birth.
Attorney, nabanggit niyo yung fraud, of course, marriage fraud. Ano? Again, also, on our past episodes, napag-usapan natin ang mga fraud na yan. No? Like, for example, yung iba yung pangalan mo. Pumasok ka na iba yung pangalan mo, iba yung ginamit mo. May mga examples kayong ibinigay noon sa ganyan. Or yung mga fake or altered documents. Ano? Yun ang na-submit. It's probably a reason for denial, ano, attorney, kung they find out na ito ay mga fake o kaya fraudulent itong mga documents na ito.
Yes, Kuya Johan, very strict din ang USCIS when it comes to fraud, right, or misrepresentation. In fact, one of the priorities before, Biden administration are people who either committed fraud, misrepresentation, crimes, kasama lahat yan, di ba? In fact, even during Obama's time, if they found you to have committed fraud or misrepresentation, right, you are priority. Meaning, pag na-deny po kayo, they can issue a notice to appear and see an immigration judge, right? But it's not the end of the world. I know that marami sa mga kababayan natin, although we don't cross the border, right? Like most of our mga nasa Southern America where they just cross the border, mga Filipino common problems naman dyan ay we use a different name to enter the US if we are very desperate to come to the US. So either, yung misrepresentation na yan, using someone else's identity or providing a false document. Limbawa, sabihin mo that you are a graduate of in accounting or you're saying that you have a business, wala naman, para lang makakuha ng tourist visa, right? Or situation where sasabihin mo mayroon kang bank account right now 5 million, yung pala hindi naman, kinausap mo lang yung bank manager to get the certification and then ultimately they found out na hey, these are not legit. So in that situation when you're applying for a green card, makikita lahat nila yung records nila. And sa mga kababayan natin na may interview sa immigration, mapa-green card interview po yan or citizenship or 751 or even going to court, the immigration officer or the government lawyer have a copy right under disposal, right, of your immigration record and history. So hindi mo pwedeng i-deny yan, right? Lalong-lalo na in the past, nakakuha ka ng work permit. Tatanungin sa'yo, how did you get the work permit? Yung pala, you filed a frivolous asylum. So, those are the things that you need to keep in mind, right? If you you meet or you have, an interview with immigration officer. So, that's a possible scenario if you commit fraud or misrepresentation, could be a reason for denial. Pero it's not at the end of the world then. I mean, there are options for you, right? You can always file a waiver, right? Sa amin kasi, Kuya Johan, if a client tells me na, hey, I came in a different name, I committed fraud, then, of course, hindi natin pwedeng i-hide yun. I'm not going to say na, hey, baka sakaling, di ba, pansin ng immigration. We don't do that, right? Some lawyers will advise na, wag na nating problemahin yan because, baka hindi makita ng immigration. But if they come to us, a client tells us that, hey, I committed marriage fraud, or rather, I committed fraud when I entered the US, right? This is what happened. Then we tell the immigration officer right away. And if there's a strong waiver, right, ipa-file na rin natin yung waiver to make sure that the case, you come in clean, and then that's also a factor in approving your case, right? It's not only the hardship ng spouse mo or parent mo, but also yung good moral character mo. Hindi yung tipong you continue of perpetrating fraud, and especially if your case would be referred to an immigration judge. Ang judges yan, magagalit sila yan. Sasabihin nila, sir, you entered in the 1990s, you came in with a different name, and then you filed an asylum under, claiming to be a member of the KBL, right, or Baki-Baka, kung ano man yung mga or LFS, yung mga League of Filipino Students who are fighting against the Marcos, yung pala, walang katotohanan yon. Right, that's the second fraud. And then you also claim that you are married, but you're not married. Then you're filing taxes na hindi sa pangalan mo. So the judge will not look at your case, in a way na bibigyan ka ng discretionary approval. So instead, magagalit sa iyo ang judge, and that will be taken against you. And what I tell clients is you need to come in clean and admit yung responsibility mo. Kasi kung aaminin mo yan, aakuin mo yan, and you know the consequence now, that committing marriage fraud is not good and it has adverse consequence, the judge would appreciate you, right? At sasabihin siya, nag-reform ka naman na, and since then on, wala ka nang ginawa, then the immigration judge might approve your waiver.
Hey, how about attorney? If it's on the flip side, the officer was not satisfied with your reasoning, with your fraud waiver application, and even the fraud waiver application was denied again. End of the road na ba, attorney, o meron pa?
Yes, I'm just looking at another filing ng prior lawyer, where they filed a fraud waiver, right? But as time passed by, Kuya Johan, right, nandyan pa naman yung petition. For example, pinetition kayo ng magulang ninyo, still available on the first filing po ninyo ang sasabihin ng immigration. The common reason for the denial, basically for the fraud waiver, would be walang extreme hardship, di ba, ng magulang mo, right? That's why it's really important to go each and every single detail that will help your case. Ano ba yung hardship na yan? Hindi lang naman may cancer ang qualifying relative mo or mayroong serious medical condition, right? Pwede ring emotional, pwede ring mental hardship, pwede ring psychological, financial, di ba? So kung ikaw ang breadwinner, right, ano mangyayari sa magulang po ninyo na wala ng trabaho, na wala ng ibang anak, di ba? So may mga sitwasyon din, Kuya Johan, where yung si nanay na qualifying relative mo, 5 ang anak sa Amerika, di ba? 4 ang American citizen at ikaw lang ang walang status o walang papel. So, sabi ng immigration, you have 4 other children who could take care of you. So, pwedeng i-deny yon. But of course, I mean, pwede namang i-refile yon saying that, look, officer, I know that there are other 4 siblings but they reside in the East Coast. But masyadong mainit doon masyadong malamig, di ba? Mga Pilipino, sasabihin, malamig doon, ayaw niyang snow. Or nasa Arizona naman yung isa na pag summer, napakainit. So, sasabihin mo, well, it's a perfect time dito sa Bay Area, it's a perfect weather for me dahil maedad na ako, etc. At saka, yung anak ko sa New York, kahit registered nurse yan, may maliliit namang anak, di ba? She cannot take care of me. O yung anak ko sa Arizona, right? Mayroong din sakit yung asawa niya, di ba? So you have to be very detailed in explaining, that extreme hardship. So probably during the prior application, bakit na-deny, hindi na-discuss ng husto ng hardship. So pwede ring i-refile. I-refile mo ulit, and hopefully this time, you mentioned and discussed everything in detail about the hardship. Or may mga pagkakataon din, Kuya Johan, na yung isang nire-review kong file it was filed like 5 years ago. Ang mother niya is 85 at that time. So, ngayon yung nanay na is 95. We're not saying that as you grow older, mas malaki ang chance mo. The reality is, as we grow older, mas marami tayong medical condition. So, itong mother dati na medyo malakas pa at 85, ngayong 90 years old na siya, is may dementia na. So, I mean, paano walang hardship yon, di ba? Kahit sabihin nating may ibang mga anak, pero yung mga anak din may mga condition din. So this person, the applicant, is the perfect one who would take care of the mother, right? Because he has a dementia, and hopefully, right, immigration would approve, extreme hardship.
I think the best defense really is yung truth, yung katotohanan. Napakadaling kung i-reason out mo yung katotohanan, I think makikita naman kaagad yan. Attorney, etong isang itinanong sa ating ng ating mga listeners, yung kanyang prior criminal conviction or criminal record, would that be a reason for denial? Prior records?
Would depende sa crimes, Kuya Johan. May tinatawag tayong felony, may tinatawag tayong aggravated felony, mayroon tayong tinatawag na petty offense, right? Or something that will not impact your immigration case. So what we do when clients come to us and say, hey, attorney, I have this domestic violence, or I have this drug admission or drug conviction. So titignan natin, it's really important to find out kung sino yung applicant. Nag-green card pa lang ba to or green card holder na, right? That's number 1. Number 2, ano yung case mo? does it fall under the petty offense exception? Kasi sa green card applicant, Kuya Johan, anything that has to do with drugs, right? Even the admission of using drugs at one point, you are barred from getting your green card. But with the exception lang yung use of marijuana less than 30 grams, yun lang pwedeng i-waive. Right? So kung methamphetamine, shabu, or ano pa ba yung mga anything that's prohibited drugs, ang conviction mo, the use of prohibited drugs, right? Conviction of that, you're barred from any relief. Pero may mga exception diyan. Pag if you're a green card holder, like one of my cases in the success story that I just wrote few weeks ago, where he was a green card holder since the 80s, right, when he was 19 years old, and then nag-asawa siya, nagkaroon 3 anak, but nalulong sa droga, diba? So pabalik-balik siya sa kulungan at sa rehabilitation, right? Gumagamit siya ng methamphetamine, and syempre those are addictive, Kuya Johan, and he's already a green card holder. So one time when he went home, right, sa Pilipinas, syempre pag nakita ng immigration may hit, di ba? So mayroong criminal record. So what they did is they conducted a secondary inspection, got his statement at umamin siya, which is nasa record naman, di ba? Na meron akong substance abuse or criminal convictions about drug use. So inisyoan siya ng notice to appear. And the good thing about mga kababayan nating green card holder, huwag kayong matakot na umuwi, right? Even if you have that kind of case, right? Hindi kayo ma-airport to airport. Once you're a green card holder, you remain a green card holder. And the good thing is you are given a day in court, di ba? So, i-refer ka sa immigration judge. Hindi kagaya ng tourist visa po kayo, right? At sasabihin nila, oh, you committed fraud and you committed crime. So, the immigration officer or the CBP officer at the airport can expeditedly remove you na wala kang right, di ba? Kasi ang Supreme Court decision niya na you don't have a lawyer, you don't have a constitutional right to a lawyer pag you're seeking admission kagaya ng mga tourist visa. Pero once you become a green card holder, you can request that you see an immigration judge so that the judge will either pardon you. So what I did was I prepared the client. He's been here for more than 40 years. He's been paying taxes. Yung last abuse niya or substance conviction niya was more than 10 years ago. He was being hired as a driver, ng may mga kapansanan. So you could just imagine yung transition niya, Kuya Johan, from a drug addict to a person of a good spouse, responsible husband, and grandfather, right? So nagdadrive na siya ngayon ng mga may kapansanan, and we emphasize to the immigration judge that hindi ka naman makakuha ng trabahong ganon, Kuya Johan, kung hindi ka binivet, di ba? Or
that's right.
Kung hindi pinadadaan sa sa fingerprinting, etc. So maganda na ang records na at that point. For the last 10 years wala naman siyang mga DUI or mga driving under influence or anything that would cause his job, So na-convince naman ang immigration judge, and in fact noong nagte-testify ang client, he was saying that he really, pinagsisihan niya lahat yun. He was really in that bad shape at that time, right? Mahirap talaga, and I think the judge understood that substance abuse ang hirap makaahon dyan, di ba? And even the judge was saying na, she was commending the client for being clean for more than 10 years na, kasi sinasabi niya na pag nahook ka na sa drugs, minsan ang hirap, alam mo yon, ang hirap maging malinis. Right? Karamihan ng mga tao bumabalik-balik kasi nalulunga sa droga. And in that situation, right, the judge actually granted relief for my client. So even if you have criminal conviction and if you think that is the end of the world for you, hiring a lawyer to advocate your case is really, really important to make sure that you get out of that mess. And like the client that I just narrated, right? We are filing for his naturalization now, and hopefully he'll become a citizen early of next year.
Nako, all right. Attorney, nabanggit niyo yung case na yan, and you've written about it. Isingit lang natin ng konti. Saan nila mapapanood or mababasa itong mga success stories ng Reeves Immigration Law Group and you personally?
Yes, I have my Facebook account at FJ Diza Immigration Lawyer, right? You can check. These are my personal journeys, right? As an immigration lawyer, it's more personalized. Meron din kaming website at www.reevesimmigration.com, right? Nandun lahat yung aming success stories at saka yung mga thank you notes ng mga clients saying that they are satisfied with our services, right? And of course, our Facebook page and Twitter, or rather X, right? Yung Reeves Immigration Law Group. You can also subscribe to our newsletter that we publish every 2 weeks, right? Dun sa Reeves Immigration Law Group. So you might encounter the same situation as yours, right? Na all this, and that's how you get client too, Kuya Johan, aside from, of course, the PHLV radio that we have in our website. And then they see our articles and our success stories, and they would say, hey, I have the same case. Can you do the same thing for me? And sometimes, yeah, this exactly is your case. So we can exactly replicate, although we don't guarantee 100%, right? What we guarantee is we work with you, we advocate your case, we work diligently on your case to make sure that you have a successful result.
That's amazing, amazing. Anyway, mga kababayan, if you'd like to contact our friends from Reeves Immigration Law Group, nakapapanood nyo sa screen, mga kaibigan, ng kanilang number. That's 415-568-3777. That's in San Francisco, California, kung saan nakabase po si Attorney Diza. Attorney, I'm gonna switch gears a little bit right now. Pinag-usapan natin itong mga petitions na ito and possible ways on how to, kung paano na de-deny. Sa employment petition naman, Attorney, paano kung, say, for example, naghihintay ka ng status ng iyong employment petition, and all of a sudden, hindi ikaw ang nagkaproblema. Ang nagkaproblema ngayon is the employer. For example, hindi na siya nag-qualify dun as a petitioner. Can that be a reason for denial, Attorney?
Yes, it's really important, and we have a lot of employment-based cases as well, in small businesses, right? So we always emphasize sa mga employer-client namin that, the ability to pay is really very important. The ability to pay is that you are petitioning an employee to come to the U.S. either as a registered nurse, as a caregiver, as a nanny, right, or as an engineer. You have to make sure that you have that ability to pay. So that's when we come in as lawyer and evaluate nasaan yung taxes mo for the last 5 years, right? And we need to see that just to make sure that you are able to pay, right? So kung halimbawa ang pinipetition mo is a teacher, right? Montessori school po halimbawa, and you are promising to pay them like 80,000 a year, right? Make sure that your taxes, right? Even if you're earning like millions in gross income, make sure that your net income have at least the equivalent, a yearly income that you're promising to your prospective employee, right? Not only from the time you file the perm or the labor certification until ang gusto ng immigration is until that applicant will immigrate to the US. So for example, kung 5 taon yung waiting time natin, Kuya Johan, right? Then they have to show that the net income of that employer must have at least that 60,000 or 80,000 which they promise to pay the employee that they're petitioning, right? So it's really important to communicate kasi minsan nakakaligtaan ng mga kababayan natin, and of course, they just rely on their accountant to prepare the taxes. And of course, ang accountant naman and tayo mismo, like we don't want to pay more to Uncle Sam, so masyadong maraming deductions, and there's a way to like tinatawag nating tax shield. But if you want to petition someone else, make sure that you can show the ability to pay. That's when we come in to always remind our kababayan natin ng mga employers that, look, this is your petition. Make sure that you have, if you're filing your taxes this year, right, April na naman, make sure that you can show that you have the ability to pay. So kung dalawa yung taong pinipetition mo, halimbawa 60,000 times 2, 120,000 dapat ang net income, hindi yung gross income na meron po kayo. Right? So very important 'yon. Now, there are situations na deny na, Kuya Johan, right? And they come to us and right, ang gagawin natin is pwede ring mag-change ng employer, di ba? So we can also recapture the priority date. So for example, pinetition ka ng employer mo ng 2019, right? At available na yung visa, pinaprocess na, and then yung employer either na-bankrupt na or wala na or ayaw na because of, relationship nasira at sasabihin sa'yo o ayaw na kitang petisyonin, right? O nakahanap na ka ng iba, right? Na ipipetition. So there's also still a way, you can always change employer. As long as the employer another employer, is willing to take over, right? Pwede nating i-file yung change of employer, or we can always recapture the priority date, right? Para hindi ka ulit mag-umpisa, right? So once you have that approved petition, we can recapture that and continue the process. So there's always a way, mga kababayan. So it's really important to consult with a lawyer kasi hindi yung isa-search mo sa internet, yun na yung knowledge mo, yun ang alam mo, right?
That's right.
And a lot of clients do that, right? Either they search internet, right? Or they ask yung kamag-anak nila or nag-a-assist dati, it's okay, right? At na-assist, natulungan naman kayo dati, right? But if a very complicated case, it won't hurt, right? In fact, it helps a lot if you consult a lawyer.
Attorney, balik ako sa family-based petition because not too long ago we talked about the CISPA, the CSPA, the Child Status Protection Act. How about for those petitions na yung mga anak nila ay nag-age out? Is that an automatic denial of their case? And what can they do?
Yeah, we need to evaluate whether they are CSPA eligible, right? As we mentioned, there's a mathematical calculation.
Yeah.
Then we have to determine kung you seek to acquire the immigrant visa or adjustment of status within 1 year from the time na nag-available yung visa. So, mga kababayan, it doesn't mean na if USCIS or the embassy says, your son aged out or your daughter aged out, hindi makakasama. That's the end of the world. You have to talk to us and evaluate your child whether CISPA eligible or not, right? And there are reasons din. Halimbawa, sasabihin ng embassy, hindi ka naman, okay, assuming that you are CSPA eligible, pero hindi ka to acquire within 1 year. So, anong gagawin natin? So, you have to evaluate the case kung, kung ang tawag nito, ang pag-seek to acquire mo ba is exempted or under exceptional circumstances, like you hire a lawyer but the lawyer failed to do his or her job, right? So you can show ineffective assistance of counsel. So things like that, it's not the end of the world for you. Or kung talaga naman na nag-age out na po yung bata, pwede rin i-repetition po ninyo. Right? It's better to have something to wait in the future than nothing at all. Or ilalaban mo, CSPA eligible ako, paano kung nilalaban mo yung CSPA eligibility for 3 to 5 years? Kung pinetition mo na yan, Kuya Johan, right? So, nakapag-establish ka na dapat ng priority date. So,
That's
either
right.
you, as the parent, can file a petition for your child or explore other options, kagaya halimbawa ng employment base.
That's right. Attorney, isa pa sa mainit na itinanong sa atin ng mga kababayan natin, itong issue ng, also we also discussed this in one of our programs. When the petitioner dies, the petition dies with the petitioner. So, is that an automatic denial or could you refile? Anong relief nila dito, attorney?
There's a humanitarian reinstatement. Pag nasa labas po kayo ng bansa, that's called humanitarian reinstatement, right? You are asking the USCIS to reinstate the approved petition because under the law, once the petitioner passed away, the petition is automatically revoked.
Revoked,
right?
okay.
Unfortunately. But if you have a substitute sponsor that consists either of your other sibling or in-laws, right, or the other parent who's still alive, they can be a substitute sponsor, but you have to show some of the factors, right, that is under the USCIS guidelines, where you have to establish that there's a disruption of family unity, right? The beneficiary is in poor health, right? There is a length of residence in the U.S., etc. So the humanitarian reinstatement is really hard to get, but there's a law that says that you can file. I would strongly advise that you still have to try it because there's the law and there's a regulation that allows you to do it. Now, the good thing about the humanitarian reinstatement, Kuya Johan, if the applicant, right, or the principal beneficiary is in the U.S., right, you can actually file an adjustment if the visa is available, right? So adjustment under 204L if the applicant was here in the U.S. when the petitioner passed. But for example, kung wala naman dito, like I have many clients consulting where, nakarating sila dito, they were able to get the visa because they going to attend the funeral. So, patay na nung pagdating dito, right? There's also an option for humanitarian reinstatement and adjustment of status, right? Consult to us so that we are able to assist you in filing the humanitarian reinstatement and adjustment and with work authorization.
And we had an extensive discussion on humanitarian reinstatement here at Immigration Law on Your Side. Mga kababayan, mangyaring balikan lamang itong episode na ito. This was this premiered December 15th, 2022, last year, almost 1 year na, attorney. Anong pinag-usapan natin ng humanitarian reinstatement. Kaya maganda na tumuto kayo po sa Immigration Law on Your Side kasi ito, nagdudugtong-dugtong ang discussions ng ating palatuntunan para mas marami po kayong malaman hinggil sa immigration. For those who just joined us, pinag-uusapan po natin ngayon mga kababayan ng common reasons for denial. Ano? So, para malaman natin kung ano yung mga actions at mga possible options kung kayo po ay na-deny under any of these circumstances na binabanggit natin. Attorney, in one of our episodes also, pinag-usapan natin itong deportation or for removal ng isa pong petition or ng isang petitioner, ng isang applicant. Would that be also a denial of the entire application if he was ordered removed? May history siya ng ganun po, attorney.
Definitely, Kuya Johan, one of the worst scenario that we encounter as lawyers is, we file, they come to us and say, I met a U.S. citizen, right? And it happened to our firm recently and said, okay, we can file the adjustment of status. You do the intake and ask the questions, right? Do you have any removal case? And they said, no. What was your immigration history? We spent a lot of time with the consultation, and we file the adjustment only to find out na, may prior removal pala, right? And sometimes as lawyers, lalong-lalo na, we rely on the consultation, right? Hindi naman pwede lahat every time ipupull out ko yung FBI records mo.
Yeah, that's right.
Or yung USCIS records mo because that's gonna be time consuming and you have to pay more money, right? If you do those things and only to find out, hey, meron ka palang removal order. The worst thing, Kuya Johan, is yung enforcement, right? So yung TNT ka, right? Nag-overstay ka lang ng visa. Minsan, lalong na kay Biden, hindi ka naman priority, di ba? Unless you commit a crime or unless may nag-report sa'yo. Pero, Kuya Johan, kung mayroon ka ng deportation order, para kang fugitive Para kang na-convict ng isang krimen that you need to be incarcerated. Ganon din sa removal order. Lalo na kung nag-lapse na yung panahon mo to appeal. Right? Kumbaga, isa ka sa mga priority. Kasi pag nakita ka ng immigration, there's a probability na they'll arrest you and diretso ka na sa home country mo. Di ba? Wala ka ng right to see a judge because you forgo that right when the judge ordered you removed because hindi ka nag-comply sa kanilang decision. And yun ang nakakatakot lalo na sa mga may anak na maliliit or may mga magulang na inaalagaan. So, is there hope? Yes, there's always hope. There are many reasons to reopen your case. So, yung kakaya ng client namin na nag-asawa ng US citizen na mayroon parang prior removal order hindi sinasabi sa amin, right? I-deny yung adjustment because there's a prior removal order. So the remedy there is you need to reopen mo yung removal proceedings ng kliyente, right? And hopefully they would kasi limited ng options mo lalong na nag-lapse na yung 30 days. Right? Ano ba yung reopening mo? Either you need to ask the government lawyer to join you, right, to reopen the case because this has been because of many equities, right? Pero itong client namin that came to us, he said na hindi niya tanggap yung removal order, which is probably true kasi nung nag-apply siya ng tourist visa, not the student visa from tourist to student, Kuya Johan, ang ginamit ng school na address, yung school nag-assist yung address ng school. So, yung denial ng student visa niya napunta sa school and then yung notice to appear napunta rin sa school and during that time any application whether mag-extend ka na ng tourist visa or mag-change ka ng student visa na deny, they'll put you in removal proceedings and at that time nakita ng judge na hindi naman bumalik or hindi naman bumalik sa kanila yung notice so they said they ordered him removed. So what we are doing now is ineffective assist not ineffective but lack of notice, right? meron akong removal order but, I didn't get the notice. I didn't get the notice of hearing and hindi ko nakuha yung removal order. That's what we're doing. Kasi pwede mo sabihin na, look, lahat ng addresses niya, right, 5 years ago, nasa Bay Area. Yung address niyo sa court, nasa LA, na hindi naman siya tumira doon, kundi that's the school's address. So hopefully, ma-reopen siya, Kuya Johan, bago, para makapag-adjust na siya before the immigration court. So, again, it's really hard sa mga kababayan natin na mayroong removal order, lalo na kung nag-attend sila ng hearing, right? Meron sila dating abogado, tapos hindi sila nag-comply sa order ng judge. But again, there might still be hope, to either reopen your case, either ineffective assistance of counsel, lack of notice, or we can probably request the government lawyer to join us to reopen the case so that you go back to immigration judge and get your green card before the immigration judge.
Nako, kaya talagang importante mga kababayan that you consult with attorneys para malaman natin kung ano yung mga actions na pwede nyong gawin because as we've said at the top of the program, being denied by the USCIS can be really, really heartbreaking, especially if you get the denial during the holidays. Kaya kailangan alam nyo kung ano yung mga next moves natin. Attorney, maraming salamat and thank you so much for giving us information about the common denial reasons ng mga applications sa USCIS. Before I let you go, Attorney, baka meron po kayong ibang mga takeaways hinggil po sa topic na ito para sa ating mga kababayan.
Maraming salamat, Kuya Johan, again. And of course, ang ating discussion ngayon is very timely kasi it's the end of the year, right? And kind of like we summarized most of our discussions at PHLV Radio, Immigration Law on Your Side, right? But of course, these are the only few reasons for the denial, right? There are many other reasons. And of course, we cannot guarantee any success if we refile or, look at your case. But what we promise here at Reeves Immigration Law Group is, we make sure that you are being, helped. We evaluate your case and, we don't give you guarantees. What we guarantee, of course, is the professional service that we do, right? At my firm, we have this free discussion with the lawyers, right? We can always email the other lawyers of my firm who might just have recent experience in similar case like your current case. And of course, every other Tuesday, we have this Zoom meeting with the other lawyers, and we share our difficult cases and we ask questions, right? What are the thoughts with these cases? So technically, you're not just hiring one lawyer when you hire us, right? There are more than 10 lawyers of the firm with this extensive experience that we have. We can guarantee you that we hopefully give you a success of your case. And again, very timely pag-usapan natin dahil Christmas time na po at hopefully yung mga cases nyo will be approved. But and if ever mayroon kayong denial or may kilala kayo, you refer it to our firm at Reeves Immigration Law Group. So meron pa tayong isang episode, Kuya Johan, at bago mag-Christmas. So maraming salamat ulit sa panunood po ninyo and keep listening and watching our program and all the programs here at PHLV Radio. And if possible, pakishare na rin po ang lahat ng mga programa na PHLV Radio.
Nako, maraming salamat po. Attorney Flomy Javier Diza, a partner at Reeves Immigration Law Group based in San Francisco, California. Mga kaibigan, ang number niyo po ay 415-568-3777. Again, that's 415-568-3777 kung meron po kayong mga tanong. And mangyari po lamang i-comment sa baba ng ating feed kung meron pa po kayong ibang mga tanong para masagot ni attorney dito po sa ating Immigration Law on Your Side here at PHLV Radio. And again, this program premiered the 6th of December 2023. And as we briefed you on top of the program that where I am based here in Las Vegas and just about a couple of blocks away from me ay nangyari nga itong active shooter situation sa University of Nevada, Las Vegas. Investigations are still ongoing at nakikiramay po ang PHLV Radio at ang Immigration Law on Your Side sa mga nasawi sa trahedyang ito from here in Las Vegas. Attorney, maraming salamat once again and we will see you next time guys here at Immigration Immigration Law on your side. Dito lamang po sa PHLV Radio. Hatid po sa atin ng ating mga kaibigan from Reeves Immigration Law Group. We'll see you next time.
Reeves Immigration Law Group has just brought you Immigration Law on Your Side. Wednesdays, 7 p.m. Pacific on PHLV Radio.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.